Welcome back. And here is Samson's take. Ambulance case. Probe the allegations of perversion of justice. In the course of this week, during a trial in the case involving the bizarre ambulance purchase case, where the minority leader in Parliament, Kersel Attoforsen, and others are involved, something happened in the courtroom. One of the accused persons, the third accused, together, who is also a witness, under cross-examination, made some rather serious allegations against the Attorney General, Godfred Dame. The allegations forming part of the testimony of this accused person are very serious. And in a country where leaders are serious about building systems of integrity, systems that work, systems that earn the respect in the Committee of Nations, they will be thoroughly investigated. They are serious, very serious, because they border on crime and professional misconduct that could cause the Attorney General to lose his license to practice law permanently. Section 1213 of the Criminal and Other Offences Act, 1960, Act 29, makes it a felony to fabricate evidence, to obstruct, and to pervert justice. Rules 13, 40, and 45 of the Legal Profession, Professional Conduct and Etiquette Rules, 2020, LI 2423, variously prohibit a lawyer from advising or suggesting to a witness to give false evidence. And they prohibit prosecution from this kind of conduct. They prohibit communication with a represented person, a person who was a lawyer in a case, to communicate with them without the consent of their lawyers. The nature of the sanctions for such conduct tell the seriousness, especially if proving against an Article 88 officer. Our Attorney General is not only the principal legal advisor to the government, it's not only the lawyer for all of us in the Republic, but he or she combines the office of the Minister for Justice. That is a sacred place. That is not a place for political party persons. He is also the leader of the bar, the leader of lawyers, and plays very critical roles on sensitive boards and committees, as well as representing the country internationally by virtue of his offices. Let those who must do what it takes to safeguard personal integrity, professional conduct and practice, and above all, the office of the Attorney General and Minister for Justice, criminal justice in this country, not let this matter slide. It is consequential, very consequential. I have seen the reaction by the release from the Attorney General's department or under the hand of the Attorney General Deputy, those reactions do not, with the greatest of respect, answer any of the allegations made in court bordering on an attempt to pervert the course of justice. If there was an attempt to plea bargain, the plea bargaining law is very clear on how to conduct that. You cannot be involved in a plea bargain with the person without their lawyer in the first place. So if it is the case that Japa Richard has been called several times, otherwise, and in meetings with the Attorney General, seeking to convince him to implicate the minority leader in the case, this is serious, and the press release does not answer it. However, the public demand on the judge is unfounded. When testifying as a witness, it is not the province of a judge to demand material proof to a testimony of a witness. No. It is the job of the one who is offering that evidence to make sure that that evidence becomes cogent, that evidence becomes potent and material for the purposes of exonerating them. It is the job of the one cross-examining or the party affected to discredit or disprove that testimony, including by making the demand you seek, that the judge should demand evidence for the claims. A judge's role here arises when the trial is over and the judge is examining the body of evidence, the testimony and documents, to make findings of fact and give judgment. We are not in a civil law country where judges participate in the trial directly. We are in a common law country where judges do not descend into the arena. And that is my take. We'll be right back.